On September 25, 1789, Congress approved a list of proposed amendments to the newly ratified Constitution. The second item on that list was 27 words long. It read, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Those 27 words have been argued over for more than 2 centuries. To understand what they meant when they were written, we have to step back to 1791, when the states ratified the Bill of Rights. The United States was barely a decade old. There was no federal police force, no national military to speak of. Defense fell to state militias, armed civilians who trained together and could be called to action in emergencies. Many of the nation's founders feared standing armies. They'd seen how European monarchs used professional soldiers to consolidate power and suppress dissent. The militia, by contrast, represented armed citizens protecting their own communities. In this context, the Second Amendment was written. The first part, "A well-regulated militia, being necessary to the security of a free state," reflects this historical reality. In the 1790s, well-regulated didn't mean heavily restricted. It meant well-organized, properly trained, equipped to function effectively. The founders saw the militia as a check on tyranny. A population capable of bearing arms could resist an oppressive government. The second part declares the operative right. The right of the people to keep and bear arms shall not be infringed. At the time, bearing arms meant carrying weapons, typically for militia service or lawful self-defense and hunting. Guns were tools that many people depended on. But how these two parts connect has been contested almost since the ink dried. Some scholars read the militia clause as a condition. The right exists because militias are necessary, suggesting the right is tied to militia service. Others read it as context. The founders are explaining why they're protecting this right, but the actual protection applies more broadly to individuals. For nearly 200 years, courts barely touched this question. The amendment existed in the Constitution, but it was rarely litigated. That changed in 2008 with District of Columbia v. Heller *. The Supreme Court ruled, for the first time, that the Second Amendment protects an individual right to possess firearms for lawful purposes like self-defense in the home. But even this landmark decision didn't settle everything. What counts as a lawful regulation? Can a state ban certain weapons? What about background checks or magazine limits? These questions continue through the courts today. Circuit courts split on specifics. Legislatures pass new regulations. Constitutional scholars continue interpreting the same 27 words in fundamentally different ways. The text of the Second Amendment is settled. Its meaning remains unsettled, not because the words are unclear, but because they describe a right whose boundaries and reasonable limits remain genuinely disputed among thoughtful, principled people.